Treaty with the Pottawatomi, February 27, 1867, ratified July 25, 1868. Articles of Agreement concluded at Washington, D.C. on the 27th day of February 1867 between the United States, represented by Louis G. Bogie, Commissioner of Indian Affairs, W.H. Watson, Special Commissioner, Thomas Murphy, Superintendent of Indian Affairs for Kansas, and Luther R. Palmer, U.S. Indian Agent, duly authorized, and the Pottawatomi tribe of Indians represented by their chiefs, braves, and headmen, to wit: Maji, Mionko, Shogwe, B.H. Bertrand, J.N. Barasa, M.B. Beaubien, L.H. Og, and G.L. Young. Whereas the Pottawatomis believe that it is for the interest of their tribe that a home be secured for them in Indian country south of Kansas while there is yet an opportunity for the selection of a suitable reservation. And whereas the tribe has the means of purchasing such reservation from funds to arrive from the sale of lands under the provisions of this treaty without interfering with the exclusive rights of those of their people who hold their lands in common to the ownership of their diminished reserve held by them in common, or with the right to receive their just proportion of the monies arising from the sale of unallotted lands known as surplus lands, now therefore it is agreed. Article 1. It being the intention of the government that a commission shall visit Indian country as soon as practicable after the ratification of the treaties contemplating the removal of certain tribes from Kansas, accompanied by delegates from the several tribes proposing to remove, it is agreed that a delegation of the Pottawatomis may accompany said commission in order to select it, if possible, a suitable location for their people without interfering with the locations made for other Indians, and if such location shall be found satisfactory to the Pottawatomis and approved by the Secretary of Interior, such tract of land not exceeding 30 miles square shall be set apart as a reservation for the exclusive use and occupancy of that tribe, and upon the survey of its lines and boundaries and ascertaining of its area and payment to the U.S. for the same as hereinafter mentioned is set forth, the said tract shall be patented to the Pottawatomi nation, provided that if the said Pottawatomi shall prefer to select a new home among Cherokees by agreement with the said Cherokees for a price within the means of the Pottawatomis, the government will confirm such agreement. Article 2. In case a new reservation shall be selected upon the lands purchased by the government from the Creek Seminoles or Choctaws, the price to be paid for said reservation shall not exceed from the cost of the same to the government of the U.S., and the sum to be paid by the tribe for said reservation shall be taken from the amount which may be received for the lands which were offered for sale to the Leavenworth Pawnee and Western Railroad Company under the treaty dated November 15, 1861, which amount shall be the common property of the tribe, except the prairie band, who shall have no interest in said reservation to be purchased as aforesaid, but in lieu thereof shall receive their pro rata share of the proceeds of the sale of said land in money as the same may be received, provided that if the U.S. shall advance the amount necessary to purchase the said reservation, the interest due upon the deferred payments for said lands sold as hereinafter provided shall, when received by the U.S., be retained and credited to said tribes interested in said reservation, or so much of said interest may be due said tribe under this treaty. And provided further that the Leavenworth Pawnee and Western Railroad Company, their successors and assigns, having failed to purchase said lands, the Atchison, Topeka, and Santa Fe Railroad Company may within 30 days after the promulgation of this treaty purchase of the said Pottawatomis their said unallotted lands, except as hereinafter provided to St. Mary's Mission at the price of $1 per acre, lawful money of the U.S., and upon filing their bond for the purchase and payment of said lands in due form to be approved by the Secretary of Interior within the time above named, the Secretary of Interior shall issue to the last named railroad company certificates of purchase, and such certificates of purchase shall be deemed and holden in all courts as evidence of title and possession in the said railroad company to all or any part of said lands, unless the same shall be forfeited as herein provided. The said purchase money shall be paid to the Secretary of Interior in trust for said Indians within 5 years from the date of such purchase, with interest at the rate of 6% per annum on all deferred payments, until the whole purchase money shall have been paid, and before any patent shall issue for any part of said lands, $100,000 shall be deposited with the Secretary of Interior to be forfeited in case the whole of the lands are not paid for as herein provided. Said money may be applied as a payment for the last 100,000 acres of said land. Payments shall also be made for at least 1/4 of said unallotted lands at the rate of $1 per acre, and when so paid, the President is authorized hereby to issue patents for the land so paid for, and then for every additional part of said land upon the payment of $1 per acre. The interest on said purchase money shall be paid annually to the Secretary of Interior for the use of said Indians. If the said company shall fail to pay the principal when the same shall become due, or to pay all or any part of the interest upon such purchase money within 30 days after the time when such payment of interest shall fall due, then this contract shall be deemed and held absolutely null and void, and cease to be binding upon either of the parties thereto, and said company and its assigned shall forfeit all payments of principal and interest made on such purchase, and all right and title legal and equitable of any kind whatsoever, and into all and every part of said lands, which shall not have been before the date of such forfeiture paid for as herein provided, however, that in case any of said lands have been conveyed to bona fide purchasers by said Atchison, Topeka and Santa Fe Railroad Company, such purchasers shall be entitled to patents for said lands so purchased by them upon the payment of $1.25 per acre, therefore, under such rules and regulations as may be prescribed by the Secretary of Interior. Article 3. After such reservations shall have been selected and set apart for the Pottawatomis, it shall never be included within the jurisdiction of any state or territory unless an Indian territory shall be organized, as provided for in certain treaties made in 1866 with the Choctaws and other tribes occupying Indian country. In which case, or in case of the organization of a legislative council or other body for the regulation of matters affecting the relations of the tribes to each other, the Pottawatomis resident thereon shall have the right to representation according to their numbers on equal terms with the other tribes. Article 4. A register shall be made under the direction of the agent and the business committee of the tribe within 2 years after the ratification of this treaty, which shall show the names of all members of the tribe who declare their desire to remove to the new reservation, and of all who desire to remain and become citizens of the U.S., and after the filing of such register in the office of the Commissioner of Indian Affairs. All existing restrictions shall be removed from the sale and alienation of lands by adults who shall have declared their intention to remove to the new reservation, but provided that no person shall be allowed to receive to his own use the avails of the sale of his land, unless he shall have received the certificate of the agent and business committee that he is fully competent to manage his own affairs. Nor shall any person also be allowed to sell and receive the proceeds of the sale of the lands belonging to his family, unless the certificate of the agent and business committee shall declare him competent to take the charge of their property, but such persons may negotiate for the sales of their property and that of their families, and any contracts for sale so made, if certified by the agent and business committee to be at reasonable rates, shall be confirmed by the Secretary of Interior, and patents shall issue to the purchaser upon full payment, and all payments for such land shall be made to the agent, and the funds by him deposited on the first of each month in some government depository to be designated by the Secretary of the Treasury in triplicate certificates of deposit, taken therefore, one to be forwarded to the Commissioner of Indian Affairs, and one to be retained at the agency, and the third to be sent to the Superintendent of Indian Affairs for Kansas, after which deposit the U.S. will be responsible for said funds until drawn out for use as hereinafter provided, and the bonds of the agent shall be increased to a sufficient amount to cover his increased liabilities under this section. Article 5. The monies received and deposited as provided in the preceding article shall be retained until the party on whose behalf it is held shall be ready to remove to the new reservation, and shall then on such part thereof as may from time to time be necessary be drawn out under the direction of the Commissioner of Indian Affairs by the agent, and expended for the benefit of the owner in providing for his removal and that of his family to the new reservation, and in such articles and for such uses as may, with the evidence of the business committee, be deemed for his best interest at his new home. Article 6. The provisions of Article 3 of the Treaty of November 1861, April 19, 1862, relative to Pottawatomis who desire to become citizens shall continue in force, with additional provisions that before patents shall issue and full payments be made to such persons, a certificate shall be necessary from the agent and business committee that the applicant is competent to manage his own affairs, and when the computation is made to ascertain the amount of the funds to the tribe to which such applicants are entitled, the amounts invested in the new reservation provided for in the treaty shall not be taken into account. And where any member of the tribe shall become a citizen under the provisions of the said treaty of 1862, the families of said party shall also be considered as citizens, and the head of the family shall be entitled to patents, and the proportional share of funds belonging to his family, and women who are also heads of families, and single women of adult age may become citizens in the same manner as males. Article 8. Where allottees under the Treaty of 1861 shall have died, or shall hereafter decease, such allottees shall be regarded for the purpose of a careful and just settlement of their estates as citizens of the U.S. and of the state of Kansas, and it shall be competent for the proper courts to take charge of the settlement of their estates under all the forms and in accordance with the laws of the state, as in the case of other citizens deceased. And in cases where there are children of Alates left orphans, guardians for such orphans may be appointed by the probate court of the county in which such orphans may reside, and such guardians shall give bonds to be approved by said court for the proper care of the person and estate of such orphans as provided by law. Article 9. It is agreed that an examination shall be made of the books of the Indian Office in order to ascertain what amount is justly due to the Pottawatomis under the provisions of their treaties of 1818 and 1829, providing for the payment of their annuities in coin, whereas they have been paid for several years in currency, and the result of such examination shall be reported to the Congress, and the difference in amount due to said Indians shall be paid to them. Article 10. It is further agreed that upon the presentation to the Department of Interior of the claims of said tribes for depredations committed by others upon their stock, timber, or other property, accompanied by evidence thereof, examination and report shall be made to Congress of the amount found to be equitably due, in order that such action may be taken as shall be just in the premises. And it is further agreed that the claims of the Pottawatomis heretofore examined and reported on by the Secretary of Interior under the Act of Congress of March 2, 1861 shall be submitted to 2 commissioners to be named by the President of the U.S. for examination, and said commissioners, after being sworn impartially to decide on said claims, shall make report of their judgment in the premises, together with evidence taken to the Secretary of Interior, and the same shall be communicated to Congress at its next session, provided that no part of the money reported due by said commissioners shall be paid until the same shall be appropriated by Congress. Article 11. The half-sections of land heretofore set apart for the mission schools, to wit, those of the St. Mary's Mission and the American Baptist Mission, shall be granted in fee simple, the former to John F. Deals, John Shoemaker, and M. Gallowd, and the latter to such party as the American Baptist Board shall designate, and the said John F. Deals, John Shoemaker, and M. Gallowd shall have the right to purchase in a compact body 10,154-100 acres of the unallotted lands at the price of $1 per acre, to be paid to the Secretary of Interior for the use of said tribe, and when the consideration shall be paid as aforesaid, the President shall issue patents to said purchasers therefor. And in selecting said 10,154-100 acres, said purchasers shall have the preference over all other parties. Article 12. No provision of this treaty shall be held to apply in such manner as to authorize any interference with the exclusive rights in their own lands of those members of the tribe who hold their lands in common, but such Indians shall be entitled to their share in the ownership of the new reservation, and it shall not be necessary at any future time to treat with the representatives of the whole people for a cession of the lands of those who hold in common, but special treaty arrangements may be made at any time with the class of persons last named for the sale of their lands, and the disposition to be made of the proceeds thereof. Article 13. All provisions of former treaties inconsistent with the provisions of this treaty shall be hereafter null and void. Article 14. The expenses of negotiating this treaty shall be paid by the U.S. not to exceed $6,000, in testimony whereof the aforenamed commissioners on behalf of the U.S. and on behalf of the Pottawatomis, the aforenamed chiefs, braves, and headmen, hereunto set their hands and seals the day and year first above mentioned. Louis V. Bogie, Commissioner of Indian Affairs. W. H. Watson, Special Commissioner. Thomas Murphy, Superintendent of Indian Affairs. L. R. Palmer, U.S. Indian Agent. Majee, his ex-mark. Mianco, his ex-mark. Shaggy Way, his ex-mark. B. H. Bertrand, J. N. Barassa, M. B. Bao Bien, L. H. O. G. George L. Young. In presence of J. N. Barassa, U.S. Interpreter. Louis S. Hayden, H. W. Farnsworth, Fidel, Jared, W. R. Irwin.